Hey guys, welcome back to JP Podcast. Today on episode 4, we have William Harlow from Bily and Harlow law firm, estate planning. They specialize in estate planning, headquartered in Houston, Texas, and have offices here in Austin, Texas. And I found out about you guys in the community magazine, right?
That's right. Yeah. What is it called? Neighbors, I think.
Yeah, I think so.
Cave.
Yeah, and I'm like, man, I actually need a estate plan for myself.
Yeah.
And so I called him. I said, hey, I'm looking for an estate plan for myself. I'm interviewing a few attorneys. We also have a few hundred agents just here in Austin that, clients will ask, hey, do you guys do estate planning? Can you connect me with somebody? And at the same time, good information for people that are watching the podcast, because we're, a brand new podcast here. As episode 4, right? We've been doing this for a very long time.
Okay.
But man, grateful for you coming out. Thank you so much for showing up.
Yeah, of course.
Yes, and thank you, guys in the background right now. We were having some detailed conversations and how these guys got to know each other. So let's jump right into it. Estate planning, right? What is it? Who needs it?
Yeah. So estate planning, I would give a rough definition. It's a plan for what happens to your stuff when you pass away or become incapacitated. So we want to kind of organize all these things so that it's easier for your loved ones to take the reins of your estate if something were to happen to you. You don't really want to leave a mess for someone to deal with. We want to get ahead of the issue as much as possible and organize your estate. Who could benefit from it? Just about everybody. Everyone I know dies at some point in their life, and some people have tax problems that can be solved with an estate plan. So some level of estate planning is good for everybody. I couldn't think of anyone that wouldn't need one.
So what happens if I don't have an estate plan? What's the consequence?
Sure. So if you don't have an estate plan, it's kind of a trick question because you really do. You go under the default laws of intestacy in whatever state you live in. So because we're here in Texas, we'll talk about how that works in Texas. It's a little different from state to state, but not too different. You have to prove errors. You have to deal with the court process and get letters of testamentary or letters of administration to deal with the assets, and it's all a judge overseen process. It can be drawn out. A pretty straightforward estate could take a year or more to administer through the court system. So we're looking at a lot of administrative burden that could otherwise be avoided or at least minimized, and expenses and perhaps assets going places that you don't want them to go. If things aren't organized, the default rule is maybe your spouse would get a portion if you're married, and then your kids would divide another fraction. So if you want to have certainty over where things are going to go, then it's definitely good to engage in estate planning. Otherwise, you're kind of falling at the whims of the statutes in place. Yeah.
So my kids would have to come, my spouse would have to come and go to the court. Hey, I am married. Here's my documentation.
Right.
Go through this whole process.
If you have a will, we'd go to the court with the will. If you don't have a will, then we use the laws of intestacy, and then we have to go prove who the heirs are in a separate hearing, take that to the probate hearing, and once the heirs are declared, then that's what you would use to figure out who's getting what share of the assets.
And in a will, can people just write down, I'm at my house, this is what I have, this is who I want it to go to? Can I just write that down, stick it in my safe?
Can you and should you would be two different questions. Okay. So I suppose that you could. Whether that's warranted, there's a whole different question.
Would they accept that or no?
There are things such as holographic wills, which is a will that's written in your own handwriting and signed by you. They are accepted, but again, it's not warranted. I would never really suggest doing that unless someone is like imminently about to die.
Yeah, I'm going right now. Let me sign something. Yeah,
that may be something that we'd want to do to save the day a little bit, but generally speaking, I wouldn't suggest doing that. And
then that whole process, like going to the court, they're going to have to hire an attorney, or is that something like they've kind of stumble their way through, or do they need to hire an attorney if they don't have one beforehand?
So in Texas, you have to have an attorney to represent you in the estate. So, we have the right to represent ourselves, but when you're representing someone's estate, you're really not representing yourself. It would be unauthorized practice of law to represent an estate without an attorney or someone authorized to practice law, right? So yeah, you'd have to get an attorney to go through probate.
Got it. So either I get an attorney on the front end or I'm going to get an attorney on the back end.
That's right.
Okay. All right. And then obviously that whole process of who you want things to go to, how you want it to go, who determines that? The court does? Or like would my spouse determine that if we were married, if we didn't have an estate plan?
If you don't have an estate plan, we're talking about statutory intestacy laws. So there's laws in place that determine, usually in a fractional share, who's entitled to what. If we're talking all community properties, Texas community property state, the assets may be divided up differently, and if you have a blended family, right, if we have spouse with children that's not of their current spouse, then we're looking at a different disposition, right? So it can get pretty messy.
Yeah.
So this is all laid out in the codes.
And that's probably where a lot of like fights with families happen, I guess.
Absolutely.
Yeah.
Absolutely.
Yeah.
Yeah.
I'm never talking to you again.
Oh yeah. And even if they do a level of planning, a little bit off topic, but even if they do some planning, usually that stuff comes out while they're doing the planning and they're able to kind of work it out. But even if they're like, oh, everything's all good, my kids would never fight. Yeah. But when there is a dollar amount,
yeah, sure,
waiting for someone to get it, that's people change.
He always loved you more.
People change. People change. Like, I want my money. Yeah. So
yeah, that's tough.
Yeah, it is tough.
That's tough.
Yeah.
Yeah. As a dad, and I know you got 2 kids and one on the way here, right?
Way, yep.
And the one on the way is in July too.
End of July, early August maybe.
Okay, got it. Because I know you were talking about birthdays in July.
Yeah, yeah.
I don't want my kids to have to go through that process, because then it puts the pressure on them to do that.
Right,
so
right.
What are the biggest mistakes that people make in estate planning that you see? I'm going to get an estate plan and I maybe go hire an attorney. What's the biggest mistake I can avoid if I'm thinking about doing estate planning?
Sure. Your mistakes are going to be reduced if you're hiring kind of a specialist estate planning attorney, whether it's me, whether it's another specialist. They're going to have, the competence to reduce the amount of mistakes. A lot of the times, if you're doing trust planning, like a revocable living trust, when you do that, there's kind of a 2-step process. You create the documents, so you sign the trust, you sign other ancillary documents that go with it, and then you have to title assets and move them into the trust. Now, not every attorney, or if someone's doing it themselves, they may not follow up with retitling all their assets, or they may acquire assets later that they, titling them in the name of their trust may not be at the top of their mind, right? I buy a new piece of real estate and I don't put it in my trust that I did 5 years ago. If I die, that asset could still be subject to probate. So then you're looking at doing a probate and dealing with the trust. So that's one kind of pitfall for trust planning. But, attorneys will usually offer, and we do offer, continued reviews of funding, make sure you're not getting other assets, annual reviews and things like that, to make sure that your beneficiary designations are good and aimed in the proper places, and that your funding of your trust is adequate. So that's kind of one aspect. Other things, when people start doing it themselves, you may run into mistakes of, I couldn't tell you how many times I've seen people come in with a will that is only notarized, which is not a valid will.
That's what?
It's not a valid will. It's only notarized. The execution requirements here say it has to have 2 unrelated witnesses.
Oh, got it. Yeah.
And then the notary would notarize the affidavit saying they all witnessed everything, right? So a notary by itself means nothing for the execution requirements. People come in with a notarized will, and I have to say this is invalid.
Yeah, I've done that in the past.
Okay.
Yeah, I did it like when I was like, I don't have that much assets, but if something happens to me, I want to make sure my family's okay. So I went to like rocketlawyer.com.
Yeah.
Filled out this form and then had a notary just like.
Yeah. So
I thought that was good.
Depending on what state you're in, each state has a little slightly different execution requirement. So I'm also licensed in California. Out there, it's 2 witnesses, no notary.
Got it.
Out here, it's 2 witnesses at a minimum, and then a notary kind of.
Yeah, people don't know these things.
Yeah, I know.
So let's say that I because I've seen that too, because we do life insurance, and so some people will like, oh, I never changed the beneficiary on that old life insurance policy. So they were married, got divorced, married again. Now they die. That insurance company has to pay the claim out to that beneficiary.
Yeah.
From a life insurance perspective.
I think, don't quote me on this, but I think that there's statutory law saying that it would kind of undermine beneficiary designations post-divorce. Most of the time that would be settled, I think, in the marital, dissolution proceedings. But, I think I dealt with it in California. I know for California that there's ways to undermine it. And also within the contract of the life insurance policy itself. I've dealt with it in the context of a 401k.
Okay.
That there was a divorce, beneficiaries never changed. But one of the clauses in the actual 401k beneficiary designation said if there was a divorce, then that designation, if it's to the old spouse, is nullified.
Oh, got it.
Now, the bad thing about that is that if there's no contingent, then it goes to your probate estate. So that was not a good situation.
Got it.
Yeah.
So, but I could see that. I could see you buy a car, you buy another asset, you buy some investments. So every time that if I have an estate plan, is it estate plan, or would I say I have a living trust?
Yeah, I can say estate plan. When I use the term, I would generally refer to we have will-based estate plans and then trust-based estate plans. So we would say the will is carrying most of the weight in the first one, the will-based plan. The trust is going to carry most of the weight in the trust-based plan. So the plan has ancillary documents, including powers of attorney, healthcare directives, things like that. So the plan is kind of all encompassing of that. So you could refer to it either way.
So does a person need a will and a trust?
If you have a trust, you usually do what's called a pour-over will.
Okay.
It's a type of will that names your trust as the beneficiary of your probate estate. So if anything is not titled in the name of your trust and has no valid beneficiary designation, it would otherwise go to probate, what the pour-over will says is pour it into my trust through the probate proceeding so we can take advantage of the plan we've laid out in the trust.
Got it. So if in your example, I went and bought another property, I never retitled it into the trust.
Yeah.
Right. Then if I had a pour over will, it would catch that property?
It would catch the property, but it wouldn't avoid the court proceeding necessarily.
Oh, got it.
So you think of it like a safety net.
Okay.
But it's one you don't want to use the safety net, right?
Okay.
It's good
so
to
you
have,
want to. So every time that somebody buys something or has any kind of asset, if they have a living trust, they want it to be named in the trust.
It's got to be titled properly.
Okay.
Because at the end of the day, what controls disposition is the title of the asset.
Okay.
So, let's say I have a living trust and I buy a rental property, and it has my name and my spouse's name, or maybe let's say I buy it with Guy as kind of a side business venture. We don't have any of the spousal rules applying to us. We're just business partners on this rental property. We own it as joint tenants with rights of survivorship, which means whoever lives longer gets the whole thing. And let's say my trust says that property, my interest in that property goes to my spouse. Because the title says joint tenants, that's going to override everything else. That's going to override whatever my trust or my will says. That will control. Likewise, a beneficiary designation would do the same kind of thing. It would override whatever your other documents said. So the title of the asset is the king of how it is disposed. So if it's your individual name, you're looking to go in with a will. If it says the trust, then the trust controls it. If it has a beneficiary designation, then that is what will control its disposition.
Got it.
Okay.
So even though you had a trust that said that property would be 50%, the fact is that you hold it as title. The way you hold it in title is going to supersede whatever your trust says.
That's right.
Okay. Yeah. And I don't know, we didn't really go through this on the questions when we talked, but as I've spoken to other professionals, they say you should transfer your property into your trust, like your home, your rental property.
Sure.
And I said, well, there's something like on a clause that kind of says if you change the title of it,
a due on sale or acceleration clause. Yeah.
Is that a concern?
For the purposes of your living trust, it wouldn't be a concern, because when you think of a living trust, it's more like a death and incapacity plan. It's not like a separate entity how you would think of as like an LLC. Like most of the time, it's not going to have its own tax ID number. It's going to use your social security number. It's not, because it's revocable, right? And you can change it and you can amend it and do all those kind of things. It doesn't have the same sort of implications that an irrevocable plan would have. So you could think of it saying like, I own this house as joint tenants, right? Now we're going to change it to where we own it 50-50 without rights of survivorship. Right.
Okay.
It's changing the way you're holding title,
Got it.
but it's not changing who the actual owner is.
Makes sense. Okay. And for a security purpose, do you see that some investors will put their property into a different like LLC
Yeah.
to
So
protect their assets?
for rentals particularly, they'll engage in, some people call it an asset isolation strategy. So let's say I have 2 rentals, right, and I don't want to subject both of them to the liability of one of them, right? If someone, gets hurt in one of them, I don't want the other one to be available for creditor claims or lawsuits. I could isolate those in separate LLCs or take advantage of what's called a series LLC and have them in different series, so that if something happens in one, the liability is contained within that series or that LLC instead of bleeding over into the rest of your estate. So how that would play in with like a trust is you would put your LLC units into your trust to be controlled when you pass away. So you think of the LLC as kind of your liability limit, and then the trust is more of like your death and incapacity plan,
Okay.
as far as a living trust.
Okay. Yeah. That's good to know. And then, so avoiding the fees of going through the whole court process is one of the benefits, and the problems and the stress and all that.
Right.
Outside of the cost of going through not having an estate plan, what does a trust or proper estate plan do to avoid like taxes or
Sure.
additional fees?
Yeah. So just kind of a quick primer on estate taxes. It's kind of like you have a total exempt amount. You think of it like a coupon, right? I have a certain amount that I can pass on to my beneficiaries without incurring an estate tax. Right now the number is incredibly high, $13.61 million. It is set to sunset in January 1st of 26 to about half of that. So we're looking at $5 million adjusted for inflation. Some people think it's going to be 7 million. We'll know when we see it, but
Is that guaranteed to happen? Like it is going to happen?
So
or will like the next president determine if that changes?
So it is guaranteed to happen, but Congress could also change it before then. So the sunset of the 2017 Tax Cuts and Jobs Act under Trump is what is causing that to happen. So his budget package was temporary. So it's going to sunset in that year, and at that point our exemption's going down.
Okay.
So to save, so for tax planning purposes, if you're looking at an estate that's over that number or over the number that it'll be in about a year and a half or 2 years.
So meaning if my estate, so right now it's 13, you said 13.61.
0.61.
0.61,
Yeah, you just call it round numbers, 13 or so.
Got it. So let's say I'm under 13 million bucks, everything that I own currently.
Yeah.
I wouldn't be subject to estate taxes.
If you died today.
If I die right now
Yeah.
on this podcast.
Yeah, God forbid.
Okay.
That's why.
Okay. Dan's CPR certified. So is Shane. So
okay,
we're good.
good. Okay, good.
So then my family would not owe
Estate taxes.
You're such a lawyer. If today, that's so funny.
Well, yeah.
I get it.
Qualified
So,
all,
Yes, that makes sense. So there wouldn't be an estate tax.
Right. If you're passing fully exempt. Yeah.
Okay.
Yeah.
But if once that sunsets,
If you're over that number.
if I'm over 5 million or whatever it reverts back to.
Yeah. Then you're looking at anything over that exempt amount, 40%.
So anybody that's done a good job of like working hard, building a business, building assets, saving, investing, buying property, like
if you're too successful, the IRS cuts to the front of the line of your children, and they cut 40% off the top of the non-exempt amount, and then you guys get the rest. Yeah.
Where's the fairness or like justice in that? Like, what's their reason for like you're too wealthy?
I suppose so. Yeah, and here's what's even a little crazier. We're talking $5 million adjusted for inflation, so maybe a total of $6-7 million. Pre-2010, it was $1 million. That was the only exemption you got. Earlier on, it was 500,000. So I mean, the number is really high, regardless, right? But it used to be way worse. So as of 2010, it was only $1 million. Before 2010.
Before 2010.
Yeah. So it went away briefly in 2010 altogether, and then they brought it back in 2011 or 12 with the higher number.
That's crazy. Okay. So it would be me and my spouse. So anything above that?
Right. So I didn't mention, that number, 13.61 million, is per person. So if you're married, you're doubling that number.
Okay.
But you have to take certain steps to make sure that it's captured, right? Because spouses can gift an unlimited amount to each other.
Okay.
We're not worried about that number when it's between spouses. When it's between non-spouses, when it's between kids or between other people, that's when you start worrying about that number. So sometimes if you leave everything to your spouse in a way that doesn't consume your coupon, so to speak, you could be leaving a lot of exemption unused, and it wouldn't be able to be captured. Then you'd be trying to force everything to pass under the spouse's exemption, the whole estate under one exemption instead of two. So you have to take a little bit of planning steps to make sure both are captured adequately.
Yeah.
Yeah.
It sounds like somebody without a law degree is going to mess up somewhere.
Yeah,
on like 1,000 occasions
I think
as
so.
of right now.
Yeah, I'm trying not to get too complicated.
Yeah, no,
but,
I'm good.
But I'm just, it's not an automatic thing that it's captured. You have to take steps to do it. Yeah,
I got you. Who do most people? So let's say we do our trust, and I'm like, hey guys, let's do this trust.
Sure.
I want this to go to my wife. I want this to go to my kids. I have to pick somebody when I'm not here to manage this, right? Like trustee or somebody.
Right. So you're saying who would you
yeah,
want?
who do most people pick? Who's a good person to pick? Should you pick your spouse? Should you pick somebody that's?
It all depends on the complexity of what we're dealing with and how able you think these people are to deal with the complexity, right? So if it's a somewhat, we call it, let's just say it's a modest estate, right? Kind of house, checkbook, 401k, kind of a straightforward deal. A savvy adult child may be fine dealing with something like that as a trustee, and there may not be any sort of tax implications to doing that. If you're dealing with some advanced plan, if you're dealing with, in some instances, if you're doing certain asset protection strategies, you have to get someone that is a third party, unrelated. So it depends on the plan, right?
Okay.
We want someone that is savvy financially.
Okay.
Depending on the types of planning or the types of assets, that may change who we pick.
So what do you do? So a couple things to that. What do you do if that other person's spouse is just not involved on the financial side of things? They're not investors. They're not financially savvy. What does somebody do?
Sure. So you could have a co-trustee to serve with the spouse to kind of take care of the day-to-day, the billing and stuff. And
would that be somebody you guys say, hey, here's a co-trustee firm?
There's professionals that do it.
Okay.
There are firms that do it.
Do you guys do it for a person that you do their trust? Is that normal for the lawyer?
Would we serve as trustees? I normally don't do that.
Okay.
I see potential ethics issues with
Okay.
me serving as a trustee in a document that I created, because I am able to get paid trustees' fees for
Got
doing
it.
that. So me putting myself in a position to get paid later on, maybe, I don't know if it's necessarily an ethical issue, but it's a potential one. So
Okay, got
I
it.
typically don't do that.
Okay.
Some people do. I know lawyers that have done that before.
Okay.
There are professional companies. Most banks have a trust department. There's other kind of non-bank affiliated professional trustee companies. We're friendly with several of them in Houston. They have a lot of assets under management, and if that becomes necessary, you can have that person take care of it.
And they have some kind of fiduciary responsibility, if they're
absolutely. Yeah.
If there's let's say it's somebody that's again a business owner, done well, saved, and there's a lot of money there or a lot of life insurance money.
Yeah.
And somebody doesn't know how to manage it, somebody else would assist in managing that.
So anytime there's a trustee involved, they always have fiduciary duties owed to the beneficiaries.
Okay.
So, they can't steal the money. They can pay themselves reasonable fees, but they can't use the money for their own benefit.
Okay.
Depending on the distribution standards, they have to follow what the trust says to do.
Okay.
And, oftentimes they'll be exonerated for maybe a otherwise prudent investment that just didn't go right. But if they make, bad investments or they're embezzling money or something like that,
Sure.
You're going to have a case for direct liability on them.
And what if you don't want your kids? One would be, what happens if you pass away with your spouse?
Right. So, whenever we set these up, as a lawyer, I have to think of the worst case scenario in every possible situation, right? So, we're going to set it up to where we've got named successors. We want to have my spouse serves, and then if she's unable to serve for whatever reason, then I'm going to name my brother or my friend or someone like that, right, to control the trust assets. On the custody of the child issue, that would be guardianship. So we also want to nominate people to serve as guardians. So we want to handle that as well. So that's another document that would go with the plan.
If a person passes away and they don't have this, what happens to kids?
They still go through guardianship proceeding.
Okay.
There's guardianship proceeding no matter what. So like you can keep assets out of probate and pass them through, but when it comes to custody of children, that's always going to go to court.
Okay.
So there's always going to be a judicial court order associated with who has custody of these children, who is responsible for them. You may not need it for their finances because we've taken care of that with the trusts, but you would still need it for their personhood. Who's going to take them to school? Who's going to take them to the doctor? Who's going to do it right? All this kind of stuff. So we would nominate them. If there is no one that you nominated, you go to the court proceeding, and usually if you have brothers and sisters or somebody, right? Ultimately, it's the judge's decision as to what would be the best fit for the children.
Okay.
And depending on the age of the children, they may get a little say of where they go if they're old enough.
Okay, got it.
Yeah.
And then what if let's say your kids are adults, but you don't want them to get like that much money that fast, because you see people that like win the lottery and their like lives become worse afterwards.
You don't want a 21-year-old getting $1 million in cash.
Yeah.
Right.
Yeah.
Going to the Ferrari dealer,
a trip to Vegas and
drop out of school.
Yeah.
Whatever. Yeah. Okay. I hear that all the time. So you can do the inheritors trust, right? So I can say my trust, my living trust, is going to create irrevocable trust for my children, each one. Or you can set it up to where there's kind of like a pot that they can all draw off of for a certain period of time. And then it would turn into individual shares whenever the youngest is 23 or 25 or whatever. But if you leave it in irrevocable trust for their benefit, you can name somebody, trusted family member, maybe it's your brother, maybe it's a good friend, to manage those assets on their behalf. So basically they have a middleman for the money. They can't just go say like, oh, I want a Ferrari, I want the new Xbox on a whim, right? And then the trustee would say, sorry, not happening. I'll pay for your tuition, I'll pay your medical bills and reasonable living expenses, but nothing too extravagant, right? So you can have the middleman that you trust. Funny story, the place I used to work at in California, he always told me this story. He had a case where somebody, they had that relationship. The parents had died. They had the uncle, I believe, is the trustee, and then the daughter. And the daughter comes to him and says, I need $500,000 from my trust so I can buy my boyfriend a tour bus for his band. And
wow.
And the trustee says, not happening.
Yeah, for
Sorry.
sure.
So you're trying to curb the worst whims of these younger people, so that you can not see your wealth squandered, everything you worked for in your life squandered, and God forbid, potentially substance issues. Right, getting a bunch of money could cause more harm than good. So people sometimes have a problem with it because they're like, oh, my kid's gonna think that they don't love me, something like that, right?
Yeah.
Where it's like, really, you're doing this because you love them,
for sure.
So you can set those up to last for a long time. You could set it up to where the trust would dissolve when they hit a certain age, 28, 30, whatever.
Okay.
Now, for asset protection and tax planning purposes, that's not really warranted. You can also set it up to where they can kind of get in to control their own sub-share.
Okay.
And still be afforded some of those.
Could I create stipulations in my trust like, okay, I will pay back your student loan if you got a 3.8 GPA that semester?
You could do like kind of incentive provisions.
Yeah. Or I will give you your wedding gift if you stay married for 5 years. Sure. Could you create all those stipulations?
If they're simple, I don't mind doing them.
Okay.
If they get too complicated, and then I tell people, they have this whole concocted plan. If this, then this. Right. and we're getting, many degrees removed, and I'm just like, who's going to enforce this? Right?
Yeah, who would?
How do we know? We're going to have to add all these different definitions. Like a classic one would be like, you have to pass a drug test before any distributions are made. And so then you have to go down the rabbit hole of what kind of drug test? Who's going to manufacture the drug test? What happens if that drug test is no longer manufactured? Then what do we, right? So like, you get a little bit involved, and then you run into enforcement issues sometimes. So if it's really straightforward, that has a really objective measure where it says you finish school, you get this, it's pretty easy.
Got it.
Those are less of a problem. But sometimes when you get really, really involved, it becomes an enforcement problem.
Okay. So when it comes to like trust and like building something where you're thinking, I want generational wealth.
Generational wealth, yeah.
Are there trusts? Because I've read that some trusts have a lifespan to it, and then there's like longer time trusts.
Sure. Every trust has a lifespan, depending on what state you're in. So in Texas, we have this rule against perpetuities, 300 years.
Okay.
So you could pass an interest in a trust 300 years before it has to vest to the individual. A lot of states are taking this modernized approach to rule against perpetuity. So you got places like, I think Alaska is like 1,000 years. Tennessee is like 360. Nevada is up there as well. But places like California follow the old common law rule of 21 years, life and being plus 21 years. So you're looking at maybe 100 years or so, based on life expectancies plus 21 years. So they call that like dynasty planning, right? It's these like smaller marketplaces like Nevada that are trying to bring in wealth.
Yeah.
So you can move some assets to Nevada and create these dynasty plans. Texas has recently got the 300-year rule against perpetuity. So that's kind of how long the trust would last. As far as how to fund those and create them, you can do those through revocable trust, like I was talking about a minute ago.
Yeah.
To where when I die, we're going to create testamentary trust for my kids, and that my assets won't go directly to them, but they'll go into a trust for their benefit. Now, the advantage to doing that is it's kind of a best case scenario. It's my kids have potential use of the assets, and maybe they have control of it, or they know someone, uncle has control of it, but they don't legally own the assets. So if they get in a car accident, right, and they get sued and they look to collect assets, they don't legally own those assets, right? So they would be creditor protected. And let's say, God forbid, they were to get divorced. Those aren't their assets, right? So those wouldn't be subject to the division, as long as it's maintained well and scrupulously. Those wouldn't be subject to the division on divorce. Another advantage is estate taxes. So, I've been talking to you about this number, right? You pass this certain number to your kids, and it's exempt. Once you pass that to them, when they die, whatever is in that trust is not included in their number. So it gets to pass down to another generation.
So that's how you see some really wealthy families
over time. Yeah.
It
can snowball. Yeah.
That makes sense. So transitioning to a couple last few questions. I own a business.
Okay.
What happens if I pass away? Does my business go in my trust?
Yeah. We would want to assign it into the trust. Now, how that would happen depends on the terms of your operating agreement or your bylaws or whatever type of business it is. So you're going to want to look at your transfer restrictions or your buy-sell agreement, or whatever it may be, to figure out if there's any problem or if you need to get consent of the other owners to move it into your trust. Sometimes that happens and it's no problem, but you still got to follow the rules.
Makes sense.
So you just got to retitle. As far as that goes, it would be the company reissuing your shares to you as your trustee rather than you as an individual.
Okay.
Yeah. And then, I'm sorry to interrupt.
No, please go.
When you do that, you also want to look at some of the aspects of the succession of the business interest. Who's going to do your part in the company? Who's going to get your interest, right? Maybe you see this sometimes, like, I went into business with you. I didn't really go into business with your spouse necessarily. Like, she doesn't have the same qualities in the business that you would. who is going to take over your role? How are we going to pay out your spouse? How are we going to determine the value of the shares? What are we going to figure out, right? So that's kind of where the business world would overlap with the estate planning world, is we're going to figure out what happens to your interest when you pass away in conjunction with your estate plan.
So I know when I started my corporation, I didn't do a lot of that stuff.
Sure.
Set it up that way. So I'm assuming if you guys are doing the estate planning, do you guys help that person on the...
Yeah, we would help them. We may get another kind of more specialized lawyer in that area involved, but work together as like a team. Yeah.
Okay. So that's if I own a business. We talked about assets as well. This is one, and this is probably just partial for me, but maybe other people. If somebody owns company stock in a private company,
yeah,
and do you have to then go change the title on that stock as well instead of to that person to their estate plan?
Yeah. So it's similar process to what I was just talking about. We want to make sure that it passes the muster of the company's governing documents before it's transferred in. And then depending on what type of estate plan you're doing, right? If you're just doing a revocable trust, it's usually not an issue.
Okay.
Because you're just changing the way you're holding title and what happens when you die.
Okay.
If you're doing some irrevocable planning, there may be a little more involved.
Okay.
That. Yeah.
And we talked about this, a couple last questions. The life insurance, because we sell life insurance,
okay,
and we know that the death benefit is, tax-free to the beneficiary.
Sure. Yeah.
But also that death benefit is then considered an asset in terms of value to the estate.
Sure.
So how do people that have life insurance avoid having to pay estate taxes on their death benefit?
Right. So, if the payout of life insurance would fall, into your estate, and your estate would still be under that 13 million number or whatever it is the year that you pass away, we're not worried about taxes. If that life insurance amount is going to push you over the edge or push you way over the edge into the taxable realm, oftentimes what people do is what's called an irrevocable life insurance trust. So it's a trust specifically mostly used for life insurance, to where they would transfer the policy, whether by gift or sale, usually sale, into this irrevocable trust, and then they would pay the premiums. They would make gifts to the trust to pay the premiums. When the person dies, the death benefits payable to the irrevocable trust, that is not included in the estate. So really you're kind of using your annual gifting to pull money in without incurring any more estate taxes. So it's a very common strategy. And I think it was more common when the exemption was lower, like I was talking about. And if you're looking at $1 million exemption and you have a house, life insurance, right, your estate's going to be over that. So ILIT planning used to be more common. I think as we see the estate tax number go down, probably end up seeing it a lot more.
That makes sense.
Yeah.
And from a life insurance perspective, I talked to you before we started filming. I asked one of our partners, I said, hey, your top producers in the insurance industry, who do they primarily service? And he mentioned medical professionals, surgeons, dentists, etc., lawyers such as yourself, business owners, and a few other groups. And then I said, who are their best referral partners? And he says, CPAs, tax professionals, and estate planning attorneys. Yep. Why are estate planning attorneys good partnerships for people that are in the life insurance industry?
Yeah, so we talked about it a little bit beforehand, but life insurance can be a great tool for estate planning. Like I was mentioning before, if you have a taxable estate and we're doing some of this irrevocable planning, those proceeds can come into your, can be paid to that irrevocable trust without incurring additional estate taxes. If you already owe estate taxes, that money can be used to pay those taxes. So you may not want to have life insurance go into your estate, the proceeds of, and incur more tax liability, right? You want it to land somewhere else that's not going to incur more tax liability and use it to pay down the existing liability. So that's one way for kind of a more high net worth estate. On kind of the more modest estate, you may have a estate where the primary asset is the residence, right? And we have multiple kids, right? Let's say we have 3 kids. You're probably not going to have all 3 kids living in the house. Maybe they decide to sell it and split the proceeds. Maybe one of them wants it. And if there's not enough cash to buy the other two beneficiaries out, they could be looking at trying to secure some sort of financing to do that. A nice, injection of life insurance proceeds could help to equalize in that situation to make it administratively much easier for everyone to get what they want out of their distributions.
So that makes sense.
Yeah.
And if it's a younger family, they're probably still carrying a mortgage.
Right.
So if they didn't want to have to sell that home, and they want to be able to, keep the family in the home, et cetera, that could be useful there.
Right.
Is there a misconception? Because I see this with buying real estate. I see it with investing, where people feel like I have to have a lot of money, or I have to have a lot of assets, or I have to have a lot of something before I do estate planning. Is that a misconception or no? Like, do you see?
I hear it a lot.
Okay.
I especially hear that when it comes to trust. People think trust means you have a lot of money. That's not necessarily the case. Maybe with irrevocable trust, that is the case.
Okay.
But with revocable trusts, it's more of like a probate avoidance type of thing with some mild amount of tax planning and incapacity protection. At a minimum, I would say everyone would benefit from having a will, at least, even if their estate is somewhat modest. Especially if you have minor kids, you want to have guardianship nominations, and you want to have things in place. If you become incapacitated, you want to have a power of attorney, so someone can access your bank accounts to pay your bills or whatever it may be, right? They can pay your rent or whatever it is. So, you want to prepare for the worst case scenario. Do you need to go whole hog and the most expensive plan immediately? Maybe not. It's case by case. But I don't think like having a whole bunch of wealth or not being ready to do it, right, is a very good reason, right? Because we don't know what's going to happen to us, right? You drive here, right? We drove here this morning, some crazy people on the road. You don't know what's going to happen, right? So,
correct.
I think anyone could benefit from it.
Okay.
And, just because you do the trust doesn't mean you can't put assets into it later. As long as you're sound of mind, you can change it too. You can amend it. You can do different things to it. So
okay.
Yeah.
So is there like an age when you guys are seeing like the average person, average family starting age?
Sure. Most people that come in are older.
Okay.
Retirees, things like that's when they're thinking about it, right?
That makes sense.
Handful of clients that have younger kids and are kind of getting going. And most of the time it's because I worked with their parents and they're like, oh, my kid needs this, right? And so I would like to see more young people do it, but, either it's not top of mind or there's other expenses that they would rather spend their money on or need to spend their money on. But I would say right now, the bulk of the people that do it are typically older, pushing toward the end of their careers or retired.
Okay.
Yeah.
And let's say somebody, they're like, you know what, this made sense. I don't know all these things. I kind of want to make sure my kids are okay, that my property can go to who I want to go to, that my family's not going to stress when that moment comes. Mm-hmm. Is there like an average cost for a living trust, a will?
Yeah. I mean, between here and California, I've practiced both places. I would say living trusts, package total, you're looking, between for single, married, you're looking between maybe 3,000 and 8,000 or so.
Okay.
All in all, could be more, could be less. These are just estimates. If you're going to go beyond, but I mean, it can go up. If you're going to engage in a lot of irrevocable planning and things like that, you can go up to 25, 30,000. So
maybe it's expensive.
It can get expensive, but when you think about it, it's like if I'm going to take advantage of, some tax planning now, we're talking about saving 40% over exemption amount. If I have to spend $50,000 to save my family and the next generations, $5 million or more.
Yeah,
that would be worth it, I would think. So
okay, great. Any last thoughts? Maybe any question that I didn't ask that you consider important in this area for anybody that's watching?
I would say if you're thinking about it, plenty of estate professionals offer free consultations. We offer free consultations. At least get a feel for it and see if it's something that could really benefit you. A lot of people think they have everything figured out and organized and don't necessarily. So at least sit down and have the discussion with somebody. I think it would be beneficial to a lot of people.
Awesome.
Yeah.
I know if I would have watched this when I was like 20, 21, 25 and like single, not married, no kids, I probably would have like, what the hell is this video about? I'm clicking
Turn it off.
I'm clicking off of this. Where's TikTok, man? Where's my next, like, come on, let me see somebody fighting or a party or dancing or something.
Exactly.
But now being 37, being a dad, you know,
Yeah.
we have our 2 boys. I know you have 2 kids, third on the way, and taking care of my folks and thinking about my siblings and what we want to do. It's definitely more important now, especially. Go ahead.
Oh yeah, I was gonna say, you know, people like, you know, like yourself, right? You got, you know, all your ducks in a row with your business, and you got everything organized, and you know, people, you know, get their investments in line. It's like, you know, it's kind of the next step, right? You don't want all that to fall apart when you go, right?
Yep.
You worked really hard during your lifetime. You want to try to keep it intact for after your lifetime as well.
Yeah.
Yeah.
You hear like stories of people that didn't have like a, you know, an estate plan and they were famous.
Big names, Prince,
Presley, I think.
I think, and then there was an issue with, I think, Aretha Franklin's. Michael Jackson had a will, I think, that went to probate out in California. There's a bunch of big names that they didn't even have any estate planning done, and I was shocked.
Yeah.
And of course, that litigation comes. Everyone's like, "Oh, I'm entitled to part of this. He was
I'm
my
his
dad."
cousin, and he loves me. And he said
Exactly.
Yeah. Well, thank you guys for coming.
Yeah.
Super helpful, super welcoming.
Okay.
You know, I called a couple local estate planning attorneys here in Austin as well, and it's so interesting because when you tell somebody, you know, hey, we have 300 agents. Hey, I'm looking for somebody for myself. Hey, we're trying to get you on a podcast. Hey, this could be a good referral source for clients. A lot of them didn't even, you know, like call back. And I'm like, you know, that's just poor customer service, I guess. And sometimes businesses get to a place where they're a place where they're too big or they're too busy and they forget the customer service part. For those that are watching, like I had a great experience conversing with you, very helpful from the phone call, very giving in the nature of, hey, how can we serve? Yes, we'll come out. We'd love to. Great people skills. You know, sometimes you meet attorneys or where they're just like, yes. Yeah, there's no personality. You guys are fun. You guys are down to earth. So it's been a great experience.
Yeah.
We'll put your contact information below in the video. Sure. And if people have questions, they can reach out or connect or meet with you guys. We have a lot of agents actually in Houston, the top earner in our company and in our agency as well. He's out of Houston with his wife, so it could be good for them to be able to refer. But guys, I hope thank you again.
Thank you so much for having me.
Yes, thank you. Hope you got some value. If you guys have questions, sometimes before I got an office, I went to look at an office. Before I bought a Ferrari, I went to look at a Ferrari. Before I bought a home, I went to look at a home. And I was always trying to like get to the next step in my life. So for many of you guys, if you want to build something for your family that your kids and spouses and siblings and whatnot, your parents, everybody can be taken care of, I think it's super important. I think most of us don't do this because we're not thinking about dying. We don't think about, you know, this is going to come. But life goes by so fast, and there are so many things that people live with. I wish I would have done that, or I should have done that. And in this area, most of the time we can't say that because we're not here. And then the people that end up paying the price for our lack of planning, you know, our family or our children or conflict between family, like this could really be avoided with just you taking the time to come up with a plan. And like William said, you know, get a consultation, meet with somebody, get educated, because that's a big part of life. So hope this added some value to you, and you probably have a bunch of other questions that I didn't get a chance to ask, so make sure that you reach out to ask. We'll see you on the next episode, everybody. Please subscribe if you have not, so that you can keep getting our content. Take care. Bye-bye.